shouldn't say merely, even though this is a motion to adjudicate or revoke, I still have not had enough time to visit with my client, who I've just learned today is in the Henderson County Jail instead of the Van Zandt County Jail. I do not have an offer yet from the DA's office, which is understandable considering that I was only recently appointed. And so what I asked the court to do today is to reset us for a revocation hearing. And in the meantime, I'm optimistic that the state and I can maybe reach a meeting of the minds, and I can visit with Ms. Chitty about that, and we can decide what we're going to do with the state's best offer on this matter.
Okay, court will set Ms. Chitty then for a contested docket on September 30th. And that'll be at 1:30.
And if I may, Your Honor, Ms. Chitty, are you being held for any other reason other than this matter here?
No, sir.
Okay. Your Honor, that being the case, I would ask the court's indulgence to consider setting a bond for Ms. Chitty. And in fact, what I'd really like the court to consider is releasing her on a PR bond until our September 30th hearing date. And
Has a motion been filed and the state been given notice?
No, Your Honor, they haven't. This is sua sponte on my behalf. Just hearing from Ms. Chitty the situation that she's in and the lack of there being any other kind of hold.
All right, court's not going to take that up without a motion and notice to the state.
Certainly. Okay, then. Well, I'll get with the state then and see if there's any horse trading that can be done there.
Okay.
And I just opened up discovery for Mr. Adams on the portal, so you should have it, Mr. Adams. If you don't, let me know and we'll figure out why you don't.
Okay, super. Appreciate that, Mr. Woodward.
All right, Ms. Chitty, we'll see you back on September 30th. And if you're still being housed in Henderson County Jail, I'll make a note to have you brought over to the Van Zandt County Jail so that you can be in person in court on that day.
Okay. Do I not get PR bonded, or I don't really understand?
No, you're being held on a motion to revoke. So right now you have a no bond. So unless the state agrees or Mr. Adams files a motion and then we argue that and I hear that and make a decision, at this time you're being held without bond because you're on straight probation.
Okay. Yes, sir.
Mr. Adams will be in contact, I'm sure.
That's correct.
Okay. All right. So we'll be adjourning Ms. Chitty's case and we'll move to Ms. Dover's case.
Thank you. I may be excused. I think that's all
Yeah.
business.
Yes, I don't think I see anywhere else on the docket. Thank you.
Okay, appreciate it, Your Honor. Would you mind telling Ms. Taberham to expect a call from me as soon as I get back to the office from the liquor store?
Yes, ma'am.
From a liquor store?
Well, it's on the way.
Okay. I'll let her know. All right.
After 12 on a Tuesday.
I'm out of gin at home.
Yeah. Put it in the universe. Come get me, T-Lap.
Want the world out there to know that I'm just a regular guy. Stay on my phone.
Yeah.
While we're waiting.
Deputy McLeish, while we're waiting on Henderson County to get Ms. Dover,
Yes, sir.
you have a proposed lineup.
Well, actually, I do, sir. We do have the other two clients in here whose attorneys are Zooming, Mr. Knoll and Mr. Wood. And then Mr. Schmidt is present with his client in the room as well. And then after that, it is the Casey Ashmore show for the day.
Okay. Okay, so you do have Mr. Bruner then,
Yes, sir.
and you have Audrey Thompson.
Yes, sir.
Okay, we'll probably go ahead and knock those two out,
Okay.
and Richard and then Casey.
Yes, sir. And then Miss Beasley is in the room with plea paperwork prepared. Yes, ma'am.
Please.
Your Honor, I may have misunderstood. If you're ready for me to bring somebody up, by all means, let me know. I'm just kind of waiting for your cue, sir.
Yeah, we were gonna try to knock out the Henderson County first so they could go and be done. And so I think we were just waiting on Miss Chitty and Miss Dover to be switched. I hated to start another hearing or get going and then them show up because they're doing this as a courtesy to us. So I was just waiting on them. If Miss Beasley is in there, let me ask, are the paperwork that I hear in the courtroom, is that the original paperwork or is this just a copy for me to go by?
Judge, she stepped out in the lobby to get signatures. We're getting you that answer.
I'm sorry. The judge had a question for you, but he's got some paperwork. He's marked up what he got. Oh, he has copies. I have original. Your Honor, did you hear that?
You have the copies, Judge. She has the
Okay.
original.
Okay, thank you. That's what I needed.
Judge, that was just so that you have a copy of what we're doing. My client signed the paperwork here.
Okay, just so you'll have the original that'll have all the signatures on it.
Yes, sir.
Okay, good, thank you. All right, is this Miss Dover?
No, sir, this is,
No, I'm sorry, I couldn't see you there.
nope, it's me. I was trying to see, do I have a lawyer or attorney? Or,
Yes,
I
yes.
forgot to ask
that's- Well, that's who Mr. Adams was. Did you see Mr. Adams earlier? He was there in the suit, red tie, I believe.
no, I didn't, but,
Oh,
it's okay. Can you tell me his name? That way I can,
yes, his name is Mitch Adams, and he appeared on screen. I'm sorry if you couldn't see him. Could you only see me?
yes, yes.
Well, he was the other person that was talking that indicated that he had been appointed about 4 or 5 days ago. And
Uh-huh.
he was asking for the case to be reset, and then he asked for you to have to be released on a personal bond.
Okay,
And then the prosecutor was also speaking about allowing the discovery portal to be opened. And then, so Mitch Adams is your court-appointed attorney, and he was under the impression that you were going to be in the Van Zandt County Jail today, and that's why he was there to meet with you. He wasn't
Oh.
aware that you were being housed in Henderson County. So
okay,
I'll have my coordinator, if she hasn't already, send over the paperwork to the Henderson County Jail so that you can have that. So you'll have his address and his phone number.
okay. Thank you.
You're welcome. Sorry about that. All right, Ms. Dover, can you see and hear me?
Yes, sir.
Okay, am I the only one you can see on your screen?
No, sir.
Can you see the other people on the screen?
Yes, sir.
Can you see the man with the beard? Casey, will you raise your hand, please? Can you see
Yes.
him?
Yes,
All
sir.
right, that's all right. So are you familiar with Mr. Ashmore?
No, sir.
Okay, he is your attorney.
Okay.
Okay, so I'm gonna go ahead and call your case at this time. This is cause number CR 21-59, State versus Ashley Faye Dover, set for arraignment. Court has appointed the Honorable Casey Ashmore to represent Ms. Dover, who's been found indigent for the purposes of appointing counsel. And Mr. Ashmore, I'm assuming you have not had a chance to meet with Ms. Dover concerning her case in the arraignment today. Is that right?
Appointed on, like Mr. Adams, I was appointed on the 20th, last Thursday. And that's my responsibility for not requesting things sooner. We've been in the middle of a lot of construction in our Terrell facility, and that's taken the focus of my attention. So I apologize, Judge, but if you can put the indictment up on the screen, we can go ahead and have the arraignment right now.
Ms. Dover, can you see this document?
Yes, sir.
Okay. I'm gonna just, can you read, write, and speak English? I know,
Yes,
I'll
sir.
speak it. Can you read, and write?
Yes,
Okay.
sir.
All right, so I'm going to just scroll down here and you just tell me if you need me to go slower or faster, okay? And this, what I'm having shown to you is the indictment in your case, all right?
Okay. Okay.
All right, go ahead, Mr. Ashmore.
Thanks, Judge. I was going to ask your indulgence. Ms. Dover, is your name spelled correctly? Ashley Faye Dover.
Yes, sir.
You see at the top, it says charge :4811 health safety code.
Yes, sir.
Okay, that's a possession of controlled substance, which is alleged to have occurred on November 26, 2020, right around Thanksgiving.
Yes, sir.
The controlled substance is methamphetamine. Do you understand? That's the allegation, right? You understand all that, correct?
Yes, sir.
And you're authorizing me to enter a plea of not guilty on your behalf and negotiate with the state on this matter, correct?
Yes, sir.
Okay. I'm sorry we haven't had a chance to meet. We'll get that squared away. Judge, I don't think we need anything else this time except a request for a pretrial, and I'll get working with the state on discovery, plea offers, et cetera.
All right, the court will find that Ms. Dover has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record. Court will set her for a pretrial hearing on October. We can either do October 12th or we can do September 28th. Mr. Ashmore, which one would you prefer? You have a few on the 28th, and I've also set you, I think, on the 12th.
Let's Judge, let's go on the 12th to give a little cushion, if I may, because I do think we're going to have a lot on the 28th.
All right, court will set Ms. Dover for pretrial on October 12th at 1:30. If you're in custody, Ms. Dover, the court will come to you. If you make bail in this case, then your court hearing will be at 9 a.m. in the morning. Do you understand?
Yes, sir.
And this will be the only notice that I can give you since you're appearing via Zoom today from the jail. So October 12th at 1:30 if you're in custody, October 12th at 9 a.m. if you're on bail. Okay?
Yes, sir. Okay.
All right, and I'll have my coordinator, if she hasn't already, send information to you at the jail so that you'll have Mr. Ashmore's contact information, okay?
Okay, thank you.
Do you have any questions at this time?
No, sir.
Okay, all right, then we'll be adjourned in this case, and I just want to thank jail staff over there for helping us Zoom today.
Hey, thanks, Judge.
All right, let me bring in if we can bring Mr. Bruner up. We're gonna let Mr. Wood join here. Hopefully his technology is working better this afternoon. Well, it doesn't look like he's having any success in joining. So I'm sorry, Mr. Bruner, if you'll just have a seat. We'll try again in just a moment. I'm gonna ask to try to bring in Mr. Kurt Knoll, Audrey Thompson. Well, it looks like we're over two. All right, we are moving on. Ms. Thompson, I'm sorry, have a seat. Your attorney's not connected, so we're gonna move on. All right, give me who's ready in the jail and we're gonna get this done.
Mr. Schmidt? Mr. Schmidt and his client are ready. Come on, sir.
All right, this is written number WR 2151, James Daniel Bustamante. And is this a writ for bail reduction?
It is, Judge. We were also here on competency status for Mr. Bustamante. I did receive and review the report prepared by Dr. Ingram. I don't know if the court's had an opportunity to review that.
I have not. What's the results of that?
Judge, substantially, Dr. Ingram believes that Mr. Bustamante is competent to stand trial. At this time, there are a few of his historical findings that we would object to, but for the purposes of competency, we will not object to his finding.
Okay. It looks like our last setting, we've been through arraignment pretrial and then 2 docket calls, and then we did the competency. So let's go ahead and discuss the offer in the case. And are you ready to announce anything on that, Mr. Schmidt?
Well, Judge, what I can tell the court is that me and Mr. Woodwhite were fairly well at a conclusion as far as our negotiations are concerned. And we had agreed to resolve this by ways of a misdemeanor or a different, a reduction, kind of a hybrid plea. So I think we were making progress and we're ready to resolve it. However, Mr. Bustamante has been charged with an additional offense in the interim, and that's why he's in custody today. We don't have a lot of information on that. And that kind of my initial consultation is what spurred my need to get him evaluated. So we're kind of in the dark about where we're going to be on the big picture. We thought we had the other one resolved, but with this new issue, we're not ready to resolve the other one.
Okay, so let's do this. I'll set this case for additional docket call post competency finding. If you have your calendar available, do we know, State, if there's going to be, has a case already been submitted for prosecution by the arresting agency?
On the new case, yes, Judge, we intend to take it to the grand jury to see if they believe that there is probable cause on Friday of this week.
Friday of this week. So either September 28th or October 12th, is either of those preferential for you?
For me, Judge, I have no preference.
Okay. we'll set Mr. Bustamante then for docket call on September 28th and CR 21-9. And then we'll go forward on your writ, Mr. Schmidt.
Thank you, Judge. Let me go ahead and proceed.
Yes, sir.
Judge, I'll call James Bustamante.
Mr. Bustamante, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, you may put your hand down. Just make sure you speak up loudly and clearly. I know you and Mr. Schmidt are standing right there next to each other, and it's going to become very easy for y'all just to kind of talk back and forth. But if I can't hear you, then I can't do what you want to do. If I can't hear you, my court reporter can't hear you. Okay, so just speak up loudly and clearly and make sure that every answer you give is an audible, not a head shake, yes or no. Okay.
Yes, sir, I understand, sir.
All right, go ahead, Mr. Schmidt.
Thank you. James, how long have you been in custody on this new offense?
60 days.
About 60 days, and you're currently being held on bonds in the amount of cumulatively of $125,000, is that correct?
Yes, sir.
And as it stands, are you able to make those bonds?
No, sir.
Now, the new offense in which you have been arrested for, the alleged victim in this case was, as far as we know, based on what we're hearing, is your father, is that correct?
Yes, sir, that's right.
And so under the circumstances, generally your father and your stepmother have been sort of your support resource, is that correct?
Yes, that's correct.
And so you may have access to funds yourself, but you do not physically have the ability to get those, is that correct?
Yes, sir, that's correct.
And the funds that you do have to post bond, are those based on VA benefits that you receive?
Yes, sir, that's correct.
And those VA benefits, where did those come from?
For military retirement, Social Security disability, service to in the Marine Corps.
How long were you in the Marine Corps?
6 years.
And did you serve overseas?
Yes, sir, that's correct.
And were you discharged honorably?
Yes, sir, honorable under medical condition.
And medical conditions, and some of the medical conditions that you sustained in the military are some of the issues that we're dealing with today, correct?
Yes, sir, that's correct.
And that includes making sure your medication has been stabilized, making sure that you're receiving VA treatment so that you can deal with your PTSD and things of that nature.
Yes, sir.
Did you sustain a traumatic head injury in overseas?
Yes, sir, that's correct.
Where was that at?
In Iraq, Alabama Bar province.
In Iraq, okay. And so at this point in time, if the judge were to reduce your bonds, do you have the ability to get back and forth to your court hearings?
Yes, sir, that's correct.
And previously to the new offense, you had not missed any court dates, is that correct?
No, sir, I never missed a court date.
And you've been in active contact and communication with me on going about your case.
Yes, sir, several times.
And you have the ability to report to a pretrial release and any conditions the judge may impose.
Yes, sir. Anything the judge wants.
And if you were to be released and your bonds reduced, you were able to post a bond, one of the first things that you would need to do is report to the VA or to the Andrews Center. Is that correct?
Yes, sir. The PTSD clinic.
Where's the PTSD clinic?
It's at the main VA hospital in Texas. It's Waco, Texas. The Waco hospital and the Waco VA hospital in Texas.
And have you been in regularly visiting that
Yes,
facility?
sir, that's correct.
And they have been monitoring your mental health status and your injuries sustained in war, is that correct?
That's correct.
And so at this point, you have medications that have been prescribed to you, but they're not really compatible with what's going on. Is that about right?
You know, the deterioration, from what I understand, the traumatic injury that I have to my right cortex is the separation from the lining of the skull.
Okay.
It's
So,
going to continue to deteriorate, so I have to continuously be monitored.
okay. So you had issues that are physiological and mental at the same time, correct?
Yes, sir, that's correct.
All right. So in addition to that, because you're aware that the alleged victim in the new offense is a family member, your conditions would prohibit you from having contact with with your father, or going around his residence. You understand that?
Yes, sir.
And you assure the court that, that you will abide by all those conditions.
Yes,
If,
sir.
if the court agrees to reduce your bond. Judge, I pass the witness.
State.
Mr. Bustamante, you have, I believe, a $25,000 bond on the older case. Is that correct? Are you still on bond for that case? Are you aware?
No, sir.
Okay. So what happened? What happened with that? Was it surrendered or was it forfeited? Are you aware?
I believe it is forfeited. Is that right?
Okay. And on the new case, and what do you know what you've been arrested for on the new case?
No, sir.
You are unaware?
Yes, sir. That's correct.
Judge, I have no further questions.
Mr. Bustamante, you magistrated at the jail when you were arrested on the new charge?
Yes, sir.
Did the judge tell you what it was that you were charged with at that time?
It was aggravated assault.
Okay, so so that's what Mr. Woodwike is asking you, if you're aware of what your new charge is.
Okay. I'm sorry. Excuse me, Your Honor.
And so, Mr. Bustamante, if the court were to reduce your bond amount, what would you be asking it to be reduced to?
PR bond?
PR, personal bond, PR bond? And if you were released, where would you reside?
I have an address in my pocket where I'm gonna go to. It's a home that they help veterans. But if that's sufficient for the court, that's as best I can be right now, because the home where I did reside when I got arrested, I was in Odessa, Texas, and I was working on my truck, and that's a long ways from here, so I don't want to go over there to Odessa. I want to stay in this area so that I can take care of this problem, this situation. And this is Edgewood, Texas.
That's where?
Edgewood, which is a lot closer than Odessa. It's 7011 State Highway 19, Edgewood, Texas, 75117.
And what type of home is that?
It's a home where they help veterans. It's like a AA program type of deal.
And so you live there? Or do you just go there?
I'll let you stay there, yes, sir. You live there, or I would live there. I'll reside there.
And Mr. Schmidt, are you aware, is this some kind of nonprofit type, or is it a contract with the Veterans Hospital? I've never heard of that.
I'm uncertain, Judge. I'd have to investigate that further.
So if that was not, if that place did not accept Mr. Bustamante, where would you go other than that?
Possibly back to the hospital in Waco. To the
Mr. Schmidt,
the main.
you know what the court's concern is. Where likely is Mr. Bustamante going to go if he makes bail?
Judge, I do understand the court's concern. Obviously, you don't want to release somebody on a PR bond who's homeless for all intents and purposes. I do know, though, that a little legwork, Mr. Bustamante is eligible for a lot of veterans assistance through his war-related injuries and discharge. So I wouldn't think that it'd be very difficult to quickly get him the assistance that he needs to make sure that he has satisfactory living conditions. It's just a matter of doing the legwork on that.
And
But-
Judge, sorry.
Let me say, but Mr. Schmidt, you wouldn't be doing the legwork on that, would you?
Sure, yes, sir.
No, because
I'd be more than happy to.
I'm assuming that Mr. Bustamante's family members, mom or dad, were probably helping with that regards before, but now his father's the alleged victim. Is that right? In the new
That's
case?
correct, Judge. Yeah, it would be me or no one else. And like I say, I'm happy to do that.
Go ahead, Ms. Heisler.
Judge, I'm sorry to interject. I just wanted to make everybody aware that the address that Mr. Bustamante provided comes back to Hickabilly Heaven RV Park in Edgewood. That's what's shown to be at that address.
And Judge, it was on a handwritten piece of paper. But like I said, Mr. Bustamante is eligible for a lot of assistance, and I'd be more than happy to do the legwork. And perhaps if the court wanted to hold off on a ruling for today's hearing and give me an opportunity to dig into that a little bit and report back, that would be fine. Because I understand the court's concern.
Okay, and I think I appreciate that recommendation because I think that's probably the wise thing to do. So what I'm going to do, Mr. Bustamante, is I'm going to take this under advisement, your request for a personal bond. State, what's your position on the request?
Judge, obviously, I think the court shares the state's concern. Mr. Bustamante was on bond for ag assault with a deadly weapon when he is arrested for yet another ag assault with a deadly weapon. We are clearly not unsympathetic to Mr. Bustamante's situation that stems from his service to our country. I believe if Mr. Schmidt can find a placement, particularly if it's through the VA and there will be some monitoring, I think the state would be less opposed. I don't think the state would agree to a PR bond, but we would be not opposed to a substantial bond reduction if there is those kinds of safeguards, both for the community and the alleged victims in both these cases. I think a lot of what our position would be is going to depend a lot on what Mr. Schmidt can find as far as a placement, and whether that's some sort of a residential facility or a VA hospital. We would obviously be very unopposed to a lot of things. If it's, again, I'm not trying to denigrate anything, but if it's Hickabilly Heaven in Edgewood, we're obviously going to be quite a bit more opposed to any sort of reduction on that.
Okay. All right. So the court's going to take it under advisement. That was a lot of feedback. Court's going to take it under advisement at this time, and I'll wait to hear back if Mr. Schmidt's able to get any more information for the court.
And Mr. Schmidt, I have opened up pre-indictment discovery for you on the new case, so you and Mr. Bustamante become fully versed in what the allegations on that are. And if you want to figure out what you're going to find as far as placement, if you want to share that with me, there's a fair possibility we can reach an agreement without having to require the court to make a ruling. At this point, I think the court and the state share certain concerns.
Fair enough. Thank you.
Okay. All right. We'll be adjourned in this hearing.
Thank you, Judge. That's all I have. My big excuse.
Yes. Thank you, Mr. Schmidt. Thank you, Mr. Bustamante. All right, who's next?
Ms. Beasley is getting Mr. Mays in the room right now.
All right, let's bring him on up. Yeah, yes, it was on this morning's docket. So this is cause number CR 21-272 and CR 21-274, State versus Keith Bernard Mays. Mr. Mays, if you will, sir, raise your right hand for me. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. May you put your hand down? Make sure you speak audibly on your answers. I have a court reporter here with me, and she's going to take down everything that we say. Mr. Mays, I have in my hand a waiver of indictment form that you have presumably signed with Ms. Beasley. I don't have the original here, so I'm just assuming that you signed a waiver of indictment wherein you're requesting the court to allow you to waive your right to grand jury indictment and proceed by information in this case. So what I need to know, Mr. Mays, is do you understand that you have a right to have your felony allegation, the possession of controlled substance and penalty group 1, less than 1 gram? You have the right to have that case presented to the grand jury, and for that grand jury to review the evidence and determine whether there is enough evidence to go forward with a prosecution in this case. You understand that you have that right?
Yes, sir.
You understand that you may also waive that right and allow the prosecutors to file what is known as an information and prosecute you on that. Do you understand that?
Yes.
And do you understand that you also have the right to waive that indictment and that you must do so intentionally, knowingly, and voluntarily. That means that it's your decision to do so, no one else's, and you understand what you're doing. Do you understand that what you would be doing if you waived indictment in this case?
Yes.
And has anyone threatened, forced, or pressured you to waive your indictment in this felony case?
No.
Okay, all right. And Ms. Beasley, do you believe Mr. Mays to be competent today?
I do, Your Honor.
And do you believe that he has waived his right of indictment as well as the other important rights that he's waiving by way of plea agreement? Do you believe that he's done so intelligently, knowingly, and voluntarily?
Yes, Your Honor.
Okay. All right. So Mr. Mays, the court's going to approve your waiver of indictment in this case and find that you have been charged by information in CR 21272 with a state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram that carries a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice. And cause number CR 21274, you're also charged by information with a Class B misdemeanor offense of driving while intoxicated. Driving while intoxicated, Class B, carries a range of punishment of up to 180 days in the county jail and a fine up to $2,000. Do you understand that range of punishment?
Yes.
And if the court would find that in your felony case, your plea agreement is that you want to plead guilty to that offense in exchange for the state's recommendation that your sentence be set at 9 months confinement in the state jail, with you receiving 2 days credit towards that sentence. In addition, you would be assessed a $1,000 fine, $290 court costs, and $35 in reimbursement fees. And in your DWI case, the recommendation is upon a plea of guilt that your punishment be 2 days confinement in the county jail with you receiving credit for 2 days of time served, a fine of $100, $270 court costs, and $15 reimbursement fees with you receiving 2 days credit for that sentence. Do you understand the plea agreement in both of these causes?
Yes.
And are you a United States citizen?
Yes.
And do you read, write, and speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
No.
And go ahead, sir. You just say no?
No.
Okay.
Yeah, no.
Okay. And in this case, you're represented by your attorney, Miss Debbie Beasley. Are you pleased with her representation of you?
Yes.
And do you have any questions about any of this paperwork that you've read and signed with her today?
No.
All right. And Ms. Beasley, you explained your client's legal and constitutional rights to him?
Yes, Your Honor, and he wishes to enter a plea.
All right. So, Mr. Page, to the charge of possession of a controlled substance, penalty group 1, less than 1 gram, how do you plead?
Guilty.
And to the charge of driving while intoxicated, how do you plead?
Guilty.
Are you pleading guilty to each one of these crimes because you are guilty of committing each one of these crimes?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty today?
No.
All right, the court will accept the defendant's plea of guilt at this time. Ms. Beasley, any objection to states 1 in each cause?
No, Your Honor.
All right, states 1, the stipulation of evidence is admitted in each cause respectively, and the court does take judicial notice of Mr. May's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close.
From the defense?
Rest and close, Your Honor.
All right, I'm going to take just a moment and review the evidence. All right, state, I keep finding that in the drug cases, there are no labs. And I think those are going to be paramount in this stipulation of evidence, at least for my review, to ensure that it is a controlled substance. Ms. Beasley, do you want to go forward without a lab being introduced in evidence? And this maybe there's a waiver of lab report due to the being a waiver of indictment?
There is a lab report, Your Honor, that has been turned over to Ms. Beasley, I believe. I'm not sure.
If y'all just want to stipulate on the record as to what the substance and the amount is so that we have a record of it.
Judge, I could also, if you, I don't know how Zoom works. If you would allow me to share my screen, I could share the lab report to the Zoom so everyone can review it, make sure that Ms. Beasley and Mr. Mays are aware of exactly what I'm talking about. And then I could email this to Ms. I believe probably Ms. Waynette, because Patty's at the jail, for inclusion.
You can share.
You've gotta, yeah, I gotta.
Can you see that, Ms. Beasley?
Yes,
Tell me when you'd like me to move it down.
now. Right there.
So, Judge, for the record, the lab report from the State of Texas Department of Public Safety Lab indicates cocaine in a net weight of 0.10 grams.
And can you go back? I just want to see the defendant's name. Okay. Okay.
Would you like me to still share, send this to Ms. Waynette or Ms. Patty for inclusion?
I don't think so. We've noted it on the reporter's record. So court does find that there was a lab provided to the defendant and that it does indicate the presence of cocaine in an amount that fits within the range of this offense. All right, then based on the evidence as presented, the court will follow the plea agreement in each case. The court hereby convicts Mr. Mays of possession of controlled substance in penalty group 1 less than 1 gram, assesses his punishment at 9 months confinement in the Texas Department of Criminal Justice State Jail Division, orders him to pay a $1,000 fine, $290 court cost, $35 reimbursement fee. I do note that I don't know if it was intentional, but there's no restitution in this case for the testing of the substance. So court also awards 2 days credit towards that sentence for time served towards that sentence. And cause number CR 21274, DWI, the court convicts Mr. Mays of that offense, assesses his punishment at 2 days confinement in the county jail, gives him credit for 2 days time already served towards his sentence, orders him to pay a fine of $100, court cost of $270, and $15 reimbursement fee in that case. Mr. Mays, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step over with the bailiff to be fingerprinted, at which time you'll be taken into custody and the sentence will be commenced.
May I be excused, Your Honor?
Yes, thank you, Ms. Beasley.
Thank you.
Your Honor, while I'm doing this, we still have Mr. Kurt Knowles and Mr. Jeff Wood's clients in here in case they can connect.
All right, let's try them again.
Judge, I've got a question, if I could ask to go out of order for a second.
Okay.
Judge, we've got some, we got a count wrong on Mr. Clifton Thomas's plea paperwork. Should I just interlineate that? It's just about his jail credit.
Is it going to TDC?
Yes,
Then no, we can't, on the judgment?
on the judgment. It's, okay,
No, TDC is not going to want an interlineated judgment. So we're going to need to reprint that judgment. They don't want whiteout or interlineations.
okay. I'll work on it. Thanks,
Mr.
Thanks,
Judge.
sir.
Ashmore, if you'll email Stephanie, she can have it printed to the jail. Just let her know what the difference in time credit should be.
Sure. I'll add on another 10 to, no, I'm kidding.
All right, Mr. Wood, are you available?
Can you hear me, Judge?
Yes. All right, Mr. Bruner, if you'll step back up, sir.
Mr. Bruner, step up. Excuse me.
All right, this is cause number CR 241, CR 242, State versus J. Michael Bruner. And today we had set Mr. Bruner for status of his competency report. Court has reviewed the competency report from Dr. Ingram on Mr. Bruner's second competency evaluation. Court finds that Dr. Ingram has found Mr. Bruner competent at this time. Go ahead, Mr. Wood, with any additional announcements.
Judge, I've had an opportunity to meet and speak to Mr. Bruner now a couple of times since that competency evaluation. There's still some significant concerns that I have. I've talked to Mr. Woodwike about this matter. I talked to him significantly yesterday about it. I think at this point, Judge, I think the appropriate thing to do is just set Mr. Bruner for a docket call, get him on the docket. Mr. Woodwike and myself are going to continue to talk, negotiate, and hopefully find some way to resolve this matter. Even at some point, maybe trying to have a in-chambers conversation with you, Judge. Can you hear me?
Yes, I'm looking over the pleadings. I'm just trying to see, he first hit docket call August of 20. Okay, court will set so I'm going to set Mr. Bruner for one final docket call. So we're going to have to make a decision. State's got to make a decision. Defense is going to have to make, the defendant's going to have to make a decision on what we're going to do. So let's see, Mr. Wood, what time did I set you this morning on your other case? Looks like.
Good. Judge, you set me one on one of the cases was in October, and the other one was for the ATR. That was in September. So I don't know, whichever one is fine by me, Judge.
Let's go October 12th.
Okay.
Mr. Bruner for October 12th. This will be the final docket call. And let's just for record's sake and for my recollection, State, will you tell me what your best offer to Mr. Bruner is on the record so I can write it down and I'll know what he either accepts or rejects or counters before our next hearing?
Judge, the state's best offer at this point is 10 years in the Texas Department of Criminal Justice, probated for 10 years. And I believe a $1,000 fine. I'm not sure exactly on the fine if we ever discuss specifically, but the state would offer at this point 10 years probated for 10 years and $1,000 fine.
Is that on each case?
That is Judge, that is on the felon in possession, and then we would actually dismiss the, I don't remember if it's ag assault or assault on a peace officer. I believe it is filed as ag assault against a public servant. State would dismiss that charge in conjunction with a plea to the felon in possession of a firearm charge.
Okay. All right, so Mr. Bruner will be back on October 12th at 1:30.
Yeah, we can do that, man. I'll get out today.
Sorry, I'm sorry, I couldn't hear you. Can you say it
10
again?
years now, I'll get out today. How about that?
I can't hear you. Say it again.
10 years probation, I'll get out today.
I think you could have been out a long time ago, Mr. Bruner. I think
Oh,
this,
no.
yeah, you could have gotten it today if you accepted it today.
Yeah.
Have a seat, Mr. Brown. Have a seat.
All right, Mr. Wood. You're free to go, sir.
Thanks, Judge.
You're welcome. Do you mean that? Do you mean that when you say thanks? I don't know if you mean
No, I mean that wholeheartedly, sir.
wholeheartedly. All right.
Wholeheartedly.
You have a great day.
All right, bye-bye.
Yeah. Mr. Knoll, are you there? I think I saw you beeping earlier. There you are.
Trying to do too many things at once, I think.
Well, hey, welcome to the party. Welcome to the party. All right, Ms. Thompson. All right, thank you for your patience, Ms. Thompson. All right, let me get here. This is cause number CR 15-506 and CR 21-193, State versus Audrey Thompson on motion to revoke and pretrial. Go ahead, Mr. Knoll.
Judge, on this past Thursday, I went to the Van Zandt County Jail to attempt to visit actually with 4 people. Miss Thompson was one of those. Miss Thompson informed me that she had hired another attorney. She gave me that attorney's number. I dialed that number. That attorney answered the phone, said he was hired. Actually, on Friday, that attorney's office said, well, actually, we hadn't been paid. I said, well, let me know if you get paid. On Monday, that attorney called and said, doesn't look like we're going to get paid. So they are not on the case. Said Miss Thompson didn't want to sit down and review discovery, didn't want to talk about either of her cases, even though I had the discovery, some 9 or 10 DVDs, along with written discovery, and obviously the motion to revoke. So when Miss Thompson wants to cooperate, maybe we can move the case along, or we can move the case along actually without her cooperation.
Ms. Thompson, do you want to say anything?
I do. I have been having problems getting along with Mr. Knoll. I put in a paper to, I guess, request a motion. I'm not really sure what the court name would be, but it's request a motion for counsel or something like that. It was supposed to get notarized last night, but I never got the paper back in the jail. So, but like I said, I've been having a lot of problems getting along with him, and I was going to hire that attorney. But because the attorney did not have enough time, because my court date was today, he didn't have enough time, they raised the price up. So that is why the attorney was not, whatever the word is, paying or whatever. Sorry.
Well, how much money did you come up with to hire the lawyer?
Well, my dad, he had $1,000, but they were going to do a payment plan with my family.
So that's the only attorney you want to represent you?
No, sir. I'm open to another attorney representing me.
Well, I'm saying, who else have you tried to hire?
Casey Sirianni is the only one I'm trying to hire.
I mean, are you going to try to hire someone else?
My family was looking, but I don't know how reliable they are, honestly.
Well, at this point, Ms. Thompson, you requested an attorney and the court appointed you Mr. Knoll. So, and you've not hired an attorney and there's no other motion to remove Mr. Knoll as your attorney. So at this time, I'm just going to set your case and Mr. Knoll, are you available on September 30th? That would be the contested docket on the motion to revoke.
September, well, let's see. I may be in trial on a 4th felony DWI case in the 7th. I would be set that day, but we actually may be reached Monday. So if
Are you number one?
let's
Are you
just-
number one?
Wait. The 7th is doing its first civil docket in more than a year next week or on the 30th. I am the number one backup case to a civil docket. And as far as Miss Thompson's cooperation with me, as the court may remember, she told the court that she had not been using drugs and would pass a drug test. And if the court, I don't know if the court has seen that yet, but she actually tested positive for meth, THC, and alcohol the day she was tested in court. And that's why there's no bond on the old case or the new one, I guess.
Are you available on September 30th? I'm not talking about August 30th. I'm about September 30th.
Well, September the 28th, if that case is not reached on the 30th, is when it will be kicked to the 28th. But let's put me down for the 28th. If I have a problem, we'll address it.
No, we're not setting for the 28th. My question is the contested docket is on September 30th. You're telling me that you may be in trial that week, but if not, you could be ready to go forward on Ms. Thompson's motion to revoke on the 30th.
Yes.
Okay, so September 30th on the motion to revoke, and I will carry, I guess there's no contested pretrial. Are you fine with moving a docket call on her case on the burglary of a building, or do you want me to carry that to pretrial?
Judge had Ms. Thompson bothered to have a sit down. She knows that in fact she confessed to the burglary. Co-defendants made statements against her. She made statements against them. They found stolen property where she was residing. And in addition to that, there was a statement made relating to another theft that would also be a felony. I think it was a 4-wheeler. So there's all kinds of stuff. And again, I think it's 9 or 10 DVDs, some of those statements by co-defendants and Ms. Thompson. So I'll be ready to go on both.
All right, I'm going to move Ms. Thompson's burglary case. I'm going to keep it on pretrial. We'll take up the motion to revoke first, and then we'll move the burglary case to pretrial on the same date. Ms. Thompson, if you have an attorney hired, they need to file they should know how to practice law, but if they don't, they need to file a notice of appearance or letter of representation with the clerk in order for me to know who they are. Okay. All right. We'll see you back on the 30th.
I think that's all I have.
Is that all you have? Okay.
I think so.
All right. Thank you, sir.
Thank you, Judge.
Yes, sir. You know, they all that, they're all, keep wearing my personal place, it's all like this. So is it. Trustee. Okay, thank you. That'd be fine, yes, ma'am.
Yep, I'm a second. Doesn't say.
No.
Ashmore, are you ready to pick off your hour?
Yeah.
Did I call you Max? Did. Are you ready?
No, give me just a sec.
He is, but sweetie, I can only bring some.
Oh, I was making sure. All right, Billy. Before we go too far down the rabbit hole. What were you?
Yeah, I do it, so I was I paid $5,000, I paid $5,000. You know, I had hired for this case and the case in Anderson County.
Yeah,
So
so
I thought,
those
you
are
know,
the problem. Okay, well, that's
Well,
fine.
I'm just saying, I mean,
So your offer from the state is ATDCJ, and I'm just gonna say what he said.
But, I haven't even talked to many people, so I don't, I won't say anything.
You tell the judge, man, I mean, don't.
I mean, I say, I don't know if it's gonna say, but I have that.
Well, I mean, it really doesn't matter what he has to say or what I have to say. I'm the only attorney on this case. I'm the only one who's filed an appearance in this case. I'm the only one who's doing shit for you in this case. And here's what I'm gonna tell you. What are you going to take where our conversation is to start? Because the problems that you have here and previously, it's not really about this. It's the previous right. So that's like, you know, just get in your own mind. Where you're, wait,
So Mr. Ashmore, ready?
Yes, sir.
All right, who you ready on?
Let's go with Mr. Fleming.
Billy Carl Fleming, Jr., CR 2119, set for pretrial.
Judge, we don't have any contested pretrial motions at this time, although I've been informed by Mr. Fleming that he's through a family member or otherwise hired his own counsel. I have passed on his current offer of 8 TDCJ and a $3,000 fine. And he's asked the court for a reset so he can investigate where this other attorney is who has not filed an appearance. And he's made it very clear to me that he feels like this other attorney's effectively relieved me of any obligation to serve him in this case.
Well, Mr. Ashmore, you know that's not true, right? You know
I do know, I did explain that to him, that there's been no appearance. No other counsel has filed a notice of appearance or motion to substitute. So I'm not out. That being said, he's asking the court to reset so he can investigate where this other attorney that he or a family member has hired on his behalf.
Mr. Fleming, who did you hire? When did you hire him?
I was only going with my brother and my wife. I have 2 charges out of Anderson County as well, Judge, and they told me that they hired an attorney out of Anderson County to take care of all 3 cases, but I haven't seen it. He was supposed to be coming to visit me, but I hadn't seen him yet, so I have no idea who he is or anything. I mean, he said he was supposed to be coming to visit me and taking this case in consideration as well as the other ones, and I haven't seen him yet, so I'm not sure, Judge. I'd be lying if I said I knew. Like I said, my brother and my wife went together and hired him.
You don't even know his name?
No, I have, like I said, they were supposed to have been visiting me this week and I haven't seen him.
Well, Mr. Fleming, for all intents and purposes, there is no attorney coming to visit you. There is no attorney representing you right now in my court, other than Mr. Ashmore. And he's the one that's been appointed by the court based on your request. So I'm not going to consider your request for a reset so that you can try to figure out who this unknown attorney is that you don't even have a name for. So I'm not going to stall the case on that ground without more information. So, Mr. Ashmore, are there any contested pretrial motions on file with the court?
No, Judge, there are not. And
Okay.
we don't anticipate there will be.
All right. So
we ask the court for a docket call and we can have that opportunity to elaborate and see if I am in fact going to be relieved or finalize whatever negotiation that the state may consider, that my client may consider.
Mr. Fleming, what I'm going to do is I'm going to set you for October 12th, and that date will be what we call a docket call date. And it's on that date that I'm going to expect to hear from you whether you're going to take a plea bargain or you're going to ask for a trial. And if you ask for a trial, then all the plea bargains go away. The court will not accept a plea bargain. If you're going to hire an attorney or you believe one has already been hired, then you need, after today's hearing, you need to go out and you need to figure out who that is. And they need to file some kind of notice of appearance, letter of representation with this court so that I can relieve Mr. Ashmore. If that doesn't happen, then Mr. Ashmore continues to be your attorney, and I don't put a pause on the case for that to happen. We're going to move forward in the case until October 12th. If that attorney never makes an appearance, then it's Mr. Ashmore is in charge of your case. And I'm asking Mr. Ashmore not to quit working on your case, but to continue working, and he's going to do so. All right. So on October 12th, either you and Mr. Ashmore will be back and will tell me what you plan to do on this case, or you and some attorney who's filed in a letter of appearance, a letter of representation will tell me what's going on the 12th. All right. So are we kind of on the same page now?
Yes, sir. I understand. I apologize. Like I said, I have no idea. My family.
It's all good, man.
I was supposed to have seen him and I hadn't seen him. So I just don't want to do something when they've hired somebody, you know?
I understand. But if you're going to have an attorney representing you, I would at least get their name. I mean,
Yes,
if this man or woman is going to be holding your legal future in their hand, I think I would want to know who that was and when they're coming, Especially if you're going to be telling a judge that, okay?
Totally understand. I totally understand. Like I said, I figured you would see it by now, but I haven't seen it.
All right, so we'll see you back. We'll see you back on October 12th.
Yes, sir. Thank you.
You're welcome.
Judge, we're ready for Jack McAllister, Your Honor.
All right, Mr. McAllister. CR 21-131. Mr. McAllister is set for a docket call.
We have a plea, Your Honor. Oh, I'm sorry. So, Your Honor, this is a failure to comply with registration, lifetime annual, and third-degree felony. The plea agreement that we have reached with the state of Texas is 7 years TDC, $2,500 fine, and $1,245, an unindicted failure to identify case. We're asking the court to accept that negotiation today.
What's the fine amount on the judgment?
I'm sorry, I thought I said that out loud. Excuse me.
Oh, I'm sorry.
$2,500. I'm sorry. No, that's my fault.
No, you said it. I meant to say, what are the court costs? $290? On the first page.
$290, yes, Judge.
And what
$290
about-
reimbursement.
How much is reimbursement?
$20.
Any restitution?
There is no restitution.
And the 1245 of the unindicted cause, is there a case reference number I can?
Yes, yes, Judge. D is in dog, A is in apple, 2021-0013.
And you said that was a failure to appear?
Failure to ID.
Failure to ID. And that's a misdemeanor case?
It is.
Judge, I'm sorry, before we proceed, may Mr. Ashmore and I go to a breakout room?
Yes.
Yes. Sorry, please, Your Honor. Yes, please.
Give me just a second. I've got to create a new one here. Zoom is not cooperating today. Let me close all of these rooms here.
No, it's going. It's just a failure.
Try this again. Hillary, did it not invite you?
It did, but then it spit me back into the courtroom.
That's weird. Okay, let's try it. Hold tight. I'm going to move you to room 1 so that I can get you. It's showing you not joined to room 2, but let me try to kick you in room 1 with Tyler and then maybe back to room 2. Hang on.
Okay.
All right, what about now?
No. Hey, Hillary? Oh, never mind.
No, I'm here.
Judge, can we stay off the record for just a second?
Off the record, do you want me to put y'all
No, it's
back?
fine. No.
Yeah, we're off the
Hillary,
record.
Did you, thank you, Judge. Did you get my prior text about Mr. Thomas, you and Tyler? And okay, you're muted.
Yes, we did, but that's Tyler's case, so I don't know anything about it. You'll have to talk to him about it.
Yeah, I was just gonna see if you could send a
Do you
paper
feel,
plane
do
across
you
the
feel
hall.
that bus? That was the bus going square over me.
Judge, we're ready to resume on Mr. McAllister. We'll address the bus in a minute.
So do we have all the issues regarding Mr. McAllister's plea squared away?
Yes,
We
Your
do.
Honor, state's ready to proceed.
All right, so 7 years TDC on an F3, $2,500 fine, 1245, that failure to ID, 290 court costs, 20 reimbursement. What about credit time towards his sentence?
263 days, and we have confirmed that. That is the accurate number.
263 days credit. All right, Mr. McAllister, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Make sure you speak up loudly and clearly so that I can hear you. All right, Mr. McAllister, did you hear the plea agreement that Mr. Ashmore just recited to the court?
Yes,
Is that the plea agreement that you want to enter into today?
I have no choice.
So yes or no, Jack?
You have no choice. Well, let's talk about what your choices are. Your choices are you can enter into a plea agreement with the state and you can accept their offer. Or you can reject their offer and you can ask this court to give you a bench trial in which I would hear the evidence and determine first if you're guilty or not guilty. If I find you guilty, then I could assess your punishment for whatever crime I find you guilty of. Or I could find you not guilty and release you. Or your third option is you could ask for a trial before a jury of your peers, and they would hear the evidence and they would decide first whether you're guilty or not guilty. And if they find that you're guilty, either they could assess punishment or I could assess punishment. And that would be your choice. So you have a lot of choices. So there's no such thing as having no choice. So do you need to speak with Mr. Ashmore again? So you know exactly what your options are, so you can make an intelligent decision, and then you can stand up there and tell me what it is that you want to do.
We'll just go through.
I get to decide if we're going to go through or not you. And right now I'm thinking maybe not. I'm thinking maybe we shouldn't go through because I'm not confident that you're confident that you know what your rights are and that you're making an informed decision today. How about that? So why don't you go have a seat? Who else you got, Mr. Ashmore? You got anyone else who is ready?
Yeah, Judge, Mr. Chumbley's in the room. May I bring him up, Your Honor?
Yes. All right, this is cause CR 21-109, State versus Daryl Chumbley, and we're set for a docket call today. Go ahead, Mr. Ashmore.
Judge, the state of Texas has offered us a TDCJ offer. We're not quite in agreement with that. The state has also discussed with myself and Mr. Chumbley, and I have touched on it briefly, a possibility of just going open to Your Honor. I'm going to ask the court for a short reset. Doesn't even have to be a very long setting, but an opportunity to talk to Mr. Chumbley about that. And we had discussed issues related to a potential cap on the time that the state might ask the court to consider if we did do an open plea to the court. So, Judge, I'm just going to ask for whatever reset the court would entertain, even if it's just 7 days or 14 days, so we can have some time to get ready for that.
What is the offer at this point from the state?
Your Honor, the state was 15 years. We extended a one-time, one-day offer for today only of 8 years to Mr. Chumley in an attempt to resolve this case without a trial. However, the state would revoke that offer and revert back to our 15-year offer at this time.
That's if Mr. Chumley doesn't accept it today?
That's correct, Your Honor.
Okay. So, Mr. Ashmore, does your client understand the state's offer and its contingencies?
Oh, yeah, I'll sign for the 8. I'm not gonna sign
Well,
for 15.
I want you to talk. Yeah, let's talk with Mr. Ashmore real quick. I don't want you to be rushed into a decision. So why don't you pull him aside, Mr. Ashmore, and you mute your device if you want.
Okay. Thanks, Judge.
All right, Mr. Chumley, have you had an opportunity to speak with Mr. Ashmore? And Mr. Ashmore, does your client want to make an announcement?
Yes, Judge, my client and I have an announcement. We've had it. Thank you for the opportunity to discuss. We've reached an agreement with the state of Texas. My client is going to accept the 8 years TDCJ offer, and we'd ask court for an opportunity. I know that the court's calendar is tight today, so we're going to ask for an opportunity to just come back on a short return and plea that.
And Judge, what I would propose is if somebody from the probation department is at the jail, I can get them a waiver of jury trial today to secure that 8 offer. And then we can reset for paperwork to be completed.
So, Mr. Ashmore, is someone there at the jail from probation that we can send over paperwork?
Yes, sir, I'm here.
Okay, we'll send over a waiver of jury trial. Mr. Ashmore, if you'll go over that with your client.
Yeah.
Sign it. Yep. And once that's signed, then what we'll do is we'll reset Mr. Chumley for probably the earliest I can get him in would be September 16th. It's not a date that I've been setting you, Mr. Ashmore. Are you available on that date?
I think I am actually here that day already.
Okay, good. So we're gonna send that out, and then once he gets that filled out, then I'll recall this case. You'll let me know, and we'll go over that document together because it has to be entered in open court.
Yes, Judge.
All right, so Mr. Shelby, just go ahead and have a seat. We're gonna have you fill out a piece of paperwork, and then we'll call your case again in just a second.
Thank you, Judge.
What about Alex Manis? Are you ready on Mr. Manis?
He's not in here, Your Honor, but his. I'm told he needs to be up here by himself. Yeah, he's, well, our motion for competency with supporting affidavit is on file. It's not on file as timely as I wanted it to be, and I apologize for that. I've had some distractions trying to get our Terrell office just to dang work, right? Phone problems, internet problems, all the problems, and I'm sorry about that. It is on file. He does need to be in here by himself, is what Deputy McLeish said, and I would agree with that.
When did you file the?
Today, Your Honor, unfortunately today.
Okay, so yes, it's not been presented to me yet, not on file with the clerk, so let's just not even call him up. We'll just have to reset him so that I can review it, and I may grant the motion without a hearing, but won't do any good to do it today because I haven't seen it.
Right.
So let's just reset him until
9/16.
No, that's a little too soon. 'Cause if I review it, if I find it, if it's presented to me today, I can review it. If I sign it, Dr. Ingram needs 30 days. So I'm thinking 10-12.
Okay.
We're just going to do 10-12. Let's not bring him up today unless you want him on the Mr. Ashmore.
No, I don't. I think that would actually be disruptive to the court's business because all three of my other clients would have to be out of this room and back into the tank and then Manis in and then out. And I know that at 4 you have a hard stop. So I'm good with that as long as the court's okay with it.
Okay. All right. Well, why don't you go back unless Mr. Clifton Thomas is ready? Why don't you go back and talk with Mr. McAllister?
Yes, Judge.
Find out what he's all about.
Yes, Judge.
Your Honor.
Yes, ma'am.
Mr. Ashmore says he is ready.
Yes.
All right, who first?
Let's do Mr. Chumley first, if I may, Your Honor.
Sure, come on back up, Mr. Chumley. We'll go back on the record in CR 21-109. And Mr. Chumley, if you'll raise your right hand, I'm going to place you under oath, sir. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. Mr. Chumley, are you wanting to waive your right to a jury trial today so that you can enter into a plea agreement with the state?
I am, Your Honor.
Has anyone threatened, forced, or pressured you to execute that waiver of jury trial?
No, sir.
You understand that your right to a jury trial is absolute. No one can take it away from you, but you can waive it if you're doing so of your own free will. You understand that?
Yes, Your Honor.
And you're telling me today that you understand that you have that right to a jury trial. And at that trial, you have the right to confront the state's evidence and witness they want to bring against you, but that you can waive that. And that's what you want to do here today so that you can accept the state's plea agreement. Is that right?
Yes, Your Honor.
Mr. Ashmore, do you join your client in requesting the court to approve the waiver or requesting the defendant to waive the right to jury trial?
Yes, Judge. In fact, we had kind of comports what we talked about doing with an open plea if we reached an impasse with Ms. Heisel in the state of Texas on this matter. So yes, we're in agreement, Your Honor.
And the state also joins in requesting the court to waive its right to jury trial as well?
That's correct. And Your Honor, I'll come over to the courthouse and sign this after the conclusion of the docket.
Okay. All right. The court's going to find that Mr. Chumley has been admonished of his right to a jury trial, that he is intelligently, knowingly, and voluntarily waived that right. The court will approve the waiver of jury trial, and we'll set this for plea on September 16th at 1:30.
Thank you, Judge. And Mr. Chumley, be excused.
Yes. Thank you, Mr. Chumley. We'll see you soon.
Thank you, Your Honor.
All right. Who are you ready on now, Mr. Ashmore?
Mr. Thomas, Your Honor.
All right, CR 2415, Clifton Glenn Thomas. And we are doing a plea today, is that correct?
Yes, Judge.
All right, what's the terms of the plea agreement?
Judge, this is a plea on evading arrest, detention with vehicle, 3804 B2A, Texas Penal Code, second degree felony. This is an enhanced offense alleged to occur 9/17/2020. Punishment, 2 years TDC, fine of $2,500. The state has agreed to 12/45/2020, 118 evading arrest detention. And fine is $2,500, court costs of $290, reimbursement fee of $90 with 208 days total jail credit. We're asking the court to accept that.
How many enhancement paragraphs are in the indictment? One, just one making this? second
Just
degree?
one. Yes, Judge, it is from 1997.
Okay. All right, so Mr. Thomas, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. All right, Mr. Thomas, you heard Mr. Ashmore, your attorney, recite the plea agreement to the court. Is that your understanding of the plea agreement and what you're asking the court to approve today?
Yes, sir.
All right, and Mr. Thomas, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
And in this case, you are represented by Mr. Ashmore, your attorney. Are you pleased with him representing you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
And Mr. Thomas, is there anything about the plea papers that you've read and signed today that you do not understand? And wherever you placed your signature, you're telling me that that is your true and correct signature?
Yes, sir.
Okay. Mr. Ashmore, do you believe Mr. Thomas to be competent today?
I do, Your Honor.
And you've explained to him his legal and constitutional rights?
I have, Your Honor. I've gotten to know Mr. Thomas pretty well, actually, over the last year. I've met his family, spoken to his mother several times, and worked with him to get this result. And we appreciate the court allowing us the almost year that this took.
Okay, so Mr. Thomas, you're charged by indictment with evading arrest or detention with a vehicle, which is normally a third-degree felony. However, the state has alleged a prior offense conviction in your case, which, if proven true, enhances the range of punishment to a second-degree felony. And a second-degree felony carries a range of punishment of not less than 2 years or more than 20 years and a $10,000 fine. What that means is, upon the enhanced range of punishment, any recommendation or any sentence down by the jury or the court would have to fall within that range of punishment of not less than 2 or more than 20. And I would find here that the recommendation of 2 years CDC fits within that range of punishment. Do you understand the plea agreement and the range of punishment in this case, Mr. Thomas?
Yes, sir.
All right. So, Mr. Thomas, I'm going to ask you, how do you plead to evading arrest or detention with a vehicle?
Yeah.
And with regards to the enhancement paragraph, the allegation alleged in the indictment, is that true or not true?
That's true.
All right. And are you pleading guilty and true because you are guilty of committing that offense and that prior allegation is true?
Yes, sir.
And has anyone threatened, forced, or pressured you to do either plead guilty or plead true today?
No, sir.
All right. Court accepts the defendant's plea of guilt and plea of true. Mr. Ashmore, any objection to states one?
No, Your Honor.
All right. States one, the evidence is admitted. Court does take judicial notice of Mr. Thomas's judicial confession. State, can anything further from the state other than the recitation of facts?
No, Your Honor.
All right. If you can go ahead and give me the summary of facts to support the plea at this time.
Judge, on the day in question, Wills Point Police Department is called out because defendant has borrowed his sister's car. There's some confusion about whether that's with permission or not. She states later that he did have permission. Wills Point stops to talk to a witness and then sees the defendant in the vehicle. Wills Point Police Department attempts to stop the car. Defendant accelerates away and returns back to his sister's house to return the motor vehicle. But he does in fact evade from the police when they're trying to stop him, ostensibly for the purpose of returning the car to his sister.
Mr. Ashmore, for that summary.
That's our understanding as well, Your Honor.
All right, then based on the evidence as presented, the court will follow the plea agreement in this case. Court convicts Mr. Clifton Glenn Thomas of evading arrest or detention with a vehicle, a second-degree felony offense, finds the enhancement paragraph to be true. Court assesses his punishment pursuant to the plea agreement at 2 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,500 fine, $290 court cost, $90 reimbursement fee. Court takes into consideration under section 1245, cause number 20-118, and the court awards Mr. Thomas 208 days credit towards his sentence for time previously served in this case. Mr. Thomas, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'll have you go with the bailiff to be fingerprinted. After that time, you'll be released back into custody. And upon getting out of TDC, you should report back to the courthouse so you can make arrangements to discharge these fines and costs. Otherwise, a warrant would issue for your arrest for not paying those. You understand?
Yes, sir.
Okay, good luck to you, sir.
Ready on Mr. McAllister, Your Honor.
All right, back on the record, CR 21-131, State versus Jack McAllister. All right, Mr. McAllister, I had you go and be given an opportunity to talk with Mr. Ashmore about your options and what you want to do in this case. And I need to be just crystal clear that you understand what you're doing here today if you want me to approve this plea agreement. Do you understand? All right, so Mr. Ashmore, what are we going to do?
My client wants to accept the plea offer of 7 years TDC.
Is that true, Mr. McAllister?
Yes, sir.
And you understand your other options that you have available?
Yes, sir.
And have you weighed those options and have you made this decision based on the consideration of all of your options? It means have you thought through all your different options and have you selected this one because this is the one that you want to do?
Yes, sir.
All right, and I'm trying to remember if we had Mr. McAllister under oath previously. Mr. McAllister, I swore you in earlier, did I not?
Yes, sir.
Okay. And I believe I asked you if you were, are you pleased with Mr. Ashmore's representation of you?
Yes, sir.
Do you have any questions about the paperwork that you've read and signed today?
No, sir.
And that's your true and correct signature throughout the paperwork, is that right?
Yes.
And Mr. Ashmore, do you believe Mr. McAllister to be competent today?
Yes, Judge.
And you've gone through all the paperwork, you've explained to him not only the evidence in the case, but the consequences of this conviction and all of the circumstances concerning this plea, is that right?
Yes, Judge. Including the fact that when he's back out, the lifetime registration, the lifetime on probation goes back into effect, which is really the crux of this case, right? Is the not reporting, the not registering in compliance with, this isn't the court's law, it's the legislature's law. This is just how it is for these kinds of offenses. We've touched on that again, just to make sure that he's aware of that. But we're not here again.
So Mr. McAllister, you are aware that if you get out and you don't register as the law tells you that you have to because of your reportable conviction, that it constitutes a new offense. You understand that? And it's going to constitute a new offense for the rest of your life. Okay. All right. So Mr. McAllister being charged with a third-degree felony offense of failure to comply with sex offender duty to register for life on annual registration. That does carry a range of punishment of not less than 2 years or more than 10 years and a $10,000 fine. Court finds that the proposed plea agreement legally fits within the range of punishment. Understanding both the plea agreement and the range of punishment, Mr. McAllister, how do you plead to that offense?
Guilty.
And are you pleading guilty because you're guilty of committing that offense?
Yes.
Court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to states one?
No, Your Honor.
States one's admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, Ms. Heisler, can you just give me the facts to support the plea?
Yes, Your Honor. Mr. McAllister was living in Wills Point, Texas under a different last name. In fact, the police had had a couple of interactions with him, and he had given this different last name to them. That's what they knew him as. Ultimately, how we came to find out that it was, in fact, Mr. McAllister was a pastor at a church Mr. McAllister had been attending. Essentially became suspicious and started doing some Facebook digging and ultimately located Mr. McAllister's Facebook profile, knew that that was the man that was going by a different name at his church, contacted the Wills Point police about his concerns. And then Wills Point went out and confirmed that Jack McAllister is his actual correct identity. That was not the identity that he had been identifying as or living as. He had been on parole and required to register, I believe in Wood County it was. And he had registered there for a short period of time after his release from prison. But shortly after that, he relocated to Wills Point. They knew he had been living in Wills Point for nearly a year under this different assumed name with no registration or tracking. And that's how this case came to be presented to the district attorney's office.
Mr. Ashmore, objection to that summary?
No, Judge, that's our understanding. understanding of the facts.
All right, then based on the evidence as presented, the court will follow the plea agreement in this case. The court hereby convicts Jack Marvin McAllister of failure to comply with sex offender duty registration requirements. A third-degree felony, assesses his punishment at 7 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,500 fine, $290 court costs, and $20 reimbursement fees. Court also takes into consideration under section 1245, a failure to ID cause DA 2021-0013. Court also awards Mr. McAllister 263 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. McAllister, once you're released from TDC, you're ordered to report to the Van Zandt County Courthouse to make arrangements to discharge your fine and court costs and other fees. Failure to do so will result in an additional warrant being issued for your arrest. Good luck to you, sir. I'm going to have you go with the bailiff to be fingerprinted.
I think that concludes my business and we're right
Well,
on.
maybe not. Maybe not. Maybe it doesn't. I need you to go out to the parking lot and see if Damien
Oh,
Terrace is there.
yeah, Damon, I called earlier and I called his mom earlier. Thanks for reminding me. I'll go right now.
Take a mask with you.
Right.
We'll just test until Mr. Ashmore.
They're all yours, so thank you very much.
Judge,
Yes, sir.
I have attempted to call Mr. Gutierrez again so the last time I physically spoke to him was around 11:51 this morning. And I called him again at 1:30, spoke to him. Sorry, last time I spoke to him was at 1:30 to ensure he was here. And looks like I missed 3 phone calls after court began. I called him again at 1:53, and I've called him again. At 1:53, I called him 2 times, and I've called him 3 times now, no answer. There does not appear to be in the parking lot, and I'm gonna ask the court to be excused.
Okay, you believe him to ever have been in the Van Zandt County Justice Center parking lot as ordered?
Just don't know. I don't know. There were 3 phone calls, but court had already commenced, so
But he's
it
not
was,
there.
it was something. It's not there now.
All right,
3
Deputy.
phone calls around.
Deputy.
Sorry.
It's okay.
She's actually on her way back to you.
Oh, she is. Okay. All right. Well, based on your statement that he's not present there at the justice court, we'll have his name called loudly, distinctly 3 times, and with no response, court's going to issue a judgment ISA.
Yes, Judge.
Thank you, Mr. Ashmore. Be careful going back.
Thank you. Yes, sir. Thanks, Judge.
Yeah. Have a good day.
You too.
Thank you, Mr. Woodward. Thank you, Ms. Heisel.
Judge, I'll be
Yes,
over
Judge, thank you.
shortly to sign those orders.
Yes, ma'am. Thank you.
I'll have some dismissal I'll need you to sign too. Just